Michaela. Everyone, thank you so much for coming today. I really appreciate it. My name is Evan Bjorkland. I'm the General Counsel at the Massachusetts Office on Disability. Happy to be here today and speak to you folks about service animals, emotional support animals, all the different types of animals and all the different laws under the sun relative to this area of law. This is something that my office, the Massachusetts Office on Disability, is heavily involved in, and we often do a lot of education around this topic. So I'm going to delve right into our training. I will say this, I am going to ask that folks wait to ask questions at the end. I'd be happy to stay here all day long. I'd be happy to give you my direct line number to ask any questions whenever you want, and then also at the end of this training. But I will say this training is specifically designed to flow through the various areas of the law so that folks have an understanding of where the gray areas are, where the different laws intersect, and normally if we have questions, I'm often going to get to those anyways. So if you could just hold your questions, write them down, I promise you I'll answer them either through the training or afterwards. So, a little bit about our office. We are a state agency, and our statutory mandate is to bring about the full participation of persons with disabilities in all aspects of life. That is a very broad, unique type of mandate, and it normally plays out in our duties and functions. Our foremost function is that we are the ADA coordinating agency for the executive branch of state government. That means that my job in most circumstances is to advise state and local governments on their ADA obligations, okay? Some of that has to do with me coming here today and doing trainings for the general public, but normally I'm usually advising our state agencies on the ADA, Section 504, and state disability laws. We're also a member of the Architectural Access Board, a board that ensures that the built environment in the Commonwealth is accessible to persons with disabilities. We are the state affiliate to the National ADA Center. The ADA actually has centers throughout the throughout the United States that advise and provide technical assistance, legal advice on the ADA. We are the New England the Massachusetts affiliate for New England. We also serve as the 911 Commission. We're a liaison for that commission. We're technical advisors to local commissions on disability. So each town in the Commonwealth can legally have a commission on disability that advises that town on everything relative to what they do and persons with disabilities. We also have a client assistance program and a client services unit. I'd mentioned before about me answering questions on service animals. Well, we have a direct line that we answer questions to and for the general public on anything disability related. So if you don't get your answer here today, or you have another issue relative to denial of services or civil rights questions around persons with disabilities, you can give our office a call, okay? So I want to just mention very briefly here, before we go into the specifics of the law, the actual laws that we're referring to here when we refer to service animals and emotional support animals. The first one being the Americans with Disabilities Act. That is the law that we're going to talk about most today. And it is generally enforced in Title II. What is Title II of the ADA? That's the obligations that state and local governments have to provide equal access to persons with disabilities, and that's enforced by the Department of Justice. There are also obligations mostly similar to the Title II obligations, but sometimes they're a little less stringent relative to public accommodations. It's kind of a confusing name because what that refers to is private entities that are open to the public. Think of your big Ys, think of your hospitals, think of your 7-Elevens in your stores, and anything that's private but generally open to the public. Another law in play is Section 504 of the Rehabilitation Act. That law is actually the precursor to the ADA and provides a lot of similar obligations to provide equal access to persons with disabilities, but it's tied to the receipt of federal funding, okay? That's how that ties in. So if an entity receives federal funding, they are under the auspices of Section 504 of the Rehab Act. As you can see, you very well may be an entity that has to follow the laws of Section 504 of the Rehab Act and also the Americans with Disabilities Act. Think a city. A city accepts federal funds for a lot of their programs. They're also a state and local government. We're also going to touch on, and not until later, we're going to touch on the Air Carrier Access Act. So when we get into the airport, we're dealing with usually laws relative to the Air Carrier Access Act. There very well may be certain portions of entities in an airport that may be Title III entities under the ADA, but generally speaking, we're referring to the Air Carrier Access Act, especially once we step on to the plane. And we're also talking about the Fair Housing Act. Okay, the Fair Housing Act definitely relates to any entity that has a dwelling. So think your standard dwelling obligations, housing, things of that nature, but also think about other areas like a higher education campus that very well may have dormitories on it, right? Fair Housing Act obligations are relative to areas like that, as there very well may be overlapping laws under Section 504 of the ADA. In our state laws here, we refer to the Public Accommodations Statute. That is very similar to Title II of the ADA and Title III of the ADA. State and local government places and private entities that are open to the public have obligations not to discriminate and provide equal access under our state laws. And those are generally enforced by the Massachusetts Commission Against Discrimination. Same thing with employment and housing discrimination under 151B. Those are enforced by the state agency, the Massachusetts Commission Against Discrimination. And there are also service animal statutes, state statutes, that are enforced by the Massachusetts Commission Against Discrimination. We often don't go too much into detail in those because oftentimes it's an odd thing in Massachusetts where the ADA is actually more stringent in certain parts relative to service animals than our state law is. The only distinction being that Massachusetts state law provides the same status for service animals in training as the ADA provides for actual service animals. So that's the only distinction in which the state law provides more protections than the federal law. One of the things I like to touch on here before we really get into service animals, and it's very, very related to the service animal question, is who is protected under the ADA, who is considered a person with a disability. And I think you'll find once I go through this definition that the definition is a lot more broad than what you think, right? We often talk about various definitions for disability, right? We know that there's a definition for disability relative to you getting Social Security disability. And that's relative to whether because of your disability you're able to work a particular job that's available in the economy. That's one definition of meeting a person with a disability. Another one would be if you're looking to receive a handicap placard or a plate for your motor vehicle. And that's relative to someone's ability to be able to walk a particular amount of distance and what sort of physical disability they have. What we're talking about here when we refer to service animals, we're referring to the civil rights definition of being a person with a disability. And what is that definition? It means that someone has to have a physical or mental impairment that substantially limits one or more major life activities. And I'll unpack that in a second. There is no exhaustive list of impairments. As you notice, there's no language in here relative to any particular type of disease or particular type of disability. The law instead requires that you focus on the limitations of the individual, not the necessary ailment or disability that they very well may have. It's very broad, right? When we refer to the ADA definition, we're referring to anything under the sun relative to someone's major life activities, right? This is a non-exhaustive list that we're listing here, but oftentimes folks would think, again, are we meeting some other type of definition of disability? Well, no. When we're referring to civil rights protections, major life activities can be anything here and then some. Sitting, working, learning, these are all major life activities. In 2010, the ADA expanded the definition to include major bodily functions, okay? So substantial limitation, not just a major life activity, but a major bodily functions. And for you legal folk out there, I think it's important to point out why they did that, okay? They expanded that definition because a lot of lawyers out there were suggesting that that the definition of being a person with a disability was very easy to basically refute. And if you could refute the fact that someone meets that definition as a person with a disability, then you basically knock the legs out of the argument that you have to provide a reasonable accommodation or you have to treat them equally. So the ADA in Congress, via case law, was basically mandated to expand the definition of disability. And what that did was, and the whole purpose of that is so that employers, so that state and local governments, so that private businesses that were open to the public focused more on actually accommodating and providing equal access rather than just trying to make a distinction between someone who meets the definition and someone who doesn't. All right? One of the things I do want to point out here for the including major bodily functions is that you can see here immune system, right? If someone is substantially limited in their major bodily function of their immune system, we very well may not see that. That may not be obvious to you and I, all right? But it's important to note that this is the definition that you need to meet, and it very well may not be obvious, right? So when we're out and we're seeing folks that have service animals, when we have employees that have service animals and they don't have a vest on, which we'll go into later, we should assume that anyone could be meeting this definition for civil rights purposes. Right? And our general obligations, I like to get away from laws and talk about our obligations, are that entities must operate in a non-discriminatory manner. That's relative to their actual treatment of folks, and it's also relative to the impact in which certain folks may have relative to particular policies. We're also required to ensure equal opportunity. Okay? And that is a very important thing. Doesn't mean that we need to put folks in a better situation than someone without a disability, but we need to, in some sort of way or fashion, as a state and local government, as a private entity, ensure equal opportunity, usually through providing a reasonable accommodation. Another important obligation is that we must permit animals to accompany people with disabilities in all areas where members of the public are allowed to go. Even more expansive than that is that any state and local government entity that an individual has access to, okay? Not just areas that are generally open to the public, but if an entity has access, an individual has access or receives a service or participates in an activity, we have to allow that individual to have a service animal with them. And another obligation is making reasonable modifications to policies, practices, and procedures. For example, we can have a no pets policy, right? That's totally fine. But we need to make the modification of that to allow for service animals and in certain instances, emotional support animals, which I'll go into in detail in just a second. So, I will now begin the service animal portion of this training. I think we're here today because there's a lot of misconceptions out there around service animals and emotional support animals. You'll see here on the top left that there's an article about an airline, an emotional support pig kicked off the flight for being disruptive. It's okay to laugh. You'll also see another article about emotional support dogs on planes, more scam than therapy. On the bottom left, you'll see there's a debate around emotional support animals intensifies. You'll see a rabbit there and a crocodile. And so we often know, and I think all of you are here today, because there's a lot of gray area around what is a service animal, what is an emotional support animal, okay? When I'm referring to service animals under the ADA, and for the next few slides, and I'll tell you when it's not the case anymore, we're not referring to housing or dwellings, we're not referring to airplanes, and we're not referring to service animals relative to employment. We're just referring to folks that interact with us as a private entity that's open to the public, or a state and local government providing services, programs, and activities. This law school is potentially both of those, okay? So keep in mind that scope. So a service animal, what is a service animal under the ADA? And the definition is simple. It is that they are a dog, sometimes a miniature horse. That's the only exception when we're referring to service animals. Dogs and a miniature horse under the ADA that is individually trained to perform tasks for people with disabilities. And what does perform tasks mean? That means that they're trained to take specific action when needed relative to someone's disability. That includes guiding people who are blind. That's an obvious type of service animal use that we refer to that a lot of folks know about. It also very well may be a service animal that alerts people who are deaf, pulling wheelchairs, protecting a person who's having a seizure, or retrieving objects. All right? People with disabilities have the right to train the dog and are not required to use a professional service dog training program. That's a very important point. Okay? So when we're referring to service animals, we're not necessarily referring to, or what would be inclusive in service animals, are guide dogs, right? A lot of folks will talk about, well, my guide dog goes to a professionally trained program. They cost $50,000 for training, and they do multiple types of services for a particular individual. Well, under the ADA for civil rights protection, that $50,000 guide dog that performs multiple services has the same protection under the law as a service animal that I go out and pick up last night at the MSPCA, and I train to do something for me as a person with a disability. There is absolutely no distinction under the ADA between those two animals. The whole point is that animal is trained to perform a particular task for a person with a disability. We often talk about and we get questions about psychiatric service animals, right? Just like guide dogs, which are under the same umbrella as service animals, psychiatric service animals are considered service animals by the Department of Justice. And why? Because they're trained to provide a task or service for an individual with a psychiatric disability. The key here is, if you're thinking about whether something's a service animal or not, is that it recognizes something and it responds to something for a person with a disability. All right? These are distinct from emotional support and companion animals. Why and how? Emotional support animals under Section 504, under the Fair Housing Act, which again we're not referring to right now, the whole point of those animals is that they're not trained to perform a particular task. The simple presence of those animals very well may offer someone a calmness, right? But they're not performed to actually do anything for a person with a disability, right? That's distinct from a service animal or a psychiatric service animal. A couple examples being that a psychiatric service animal could calm a person during a panic attack by performing something, licking someone, recognizing that someone's having a panic attack and very well maybe getting them out of the room or doing something for them to alleviate those particular symptoms. Another thing would be reminding them to take their anti-anxiety medication. Assisting someone with PTSD. And I want to go into that one because I think there's a misconception out there around PTSD animals, okay? What we're referring to when we refer to a psychiatric service animal that will help someone or assist someone with PTSD, and this isn't the only way that this could be, but the general understanding of a PTSD psychiatric service animal is a dog that will come into a room prior to an individual with PTSD entering there and scan the room and then report back to that individual with wagging their tail, blinking, licking, doing some sort of thing, reporting back to that individual on whether it's too anxious in that room for that person to come in or it's not. What is it doing there? It's performing a particular service for a person with a disability. That's distinct from something that we hear about a lot, which is that in hospitals, in various veterans areas, we're hearing that there are PTSD therapy animals. Well, PTSD therapy animals, if they're not trained to actually perform a particular task, and their simple presence is comforting to someone who has PTSD, that wouldn't be considered a service animal under the Americans with Disabilities Act. So you can see it's a little nuanced there, but the distinction is the training. And another thing would be interrupting a compulsive behavior. If someone has a compulsive behavior, a service animal is trained to recognize that compulsive behavior and interrupt that compulsive behavior so it doesn't happen anymore. Miniature horses. So I said before that under the ADA, their service animals are dogs, with the small exception of miniature horses. The ADA actually allows miniature horses. Believe it or not, if you have a lot of free time on your hands, you can take a look at the congressional record on the various different types of animals that they considered besides dogs and service animals, including spider monkeys and a lot of other types of animals. There's a lot of conversation going back and forth, but they decided to pick horses, mostly to do with the fact that they have a longer service life than most dogs. They're very good for helping folks with bounce. They're very trainable types of animals. And for religious reasons, certain folks very well may not have been able to have dogs that are service animals. So just like a service dog, and we'll go into it in a bit, covered entities must permit a miniature horse as a service animal based on whether that miniature horse is housebroken, whether the miniature horse is under control, or whether the facility can accommodate the horse's type, size, and weight, and whether the horse's presence will compromise legitimate safety requirements necessary for safe operation of the service. Those last two prongs right there, those are specific to a miniature horse. The other two ones also relate to dogs, which we'll go into on the next slide. All right? So for example, there very well may be certain types of facilities and certain types of environments that can accommodate a miniature horse as a service animal, but can accommodate a dog. And those are the only two types. So the rights and responsibilities. Well, as I mentioned, service animals, miniature horse, dog for the most part, permitted anywhere the handler may go. This includes the exam rooms, the cafeterias, the waiting rooms, and we'll go into the specific health codes and things of that and then later on. But that's the general understanding here. Wherever that person can go, that animal can go, right? When we're talking about a reasonable accommodation or some sort of device to assist someone as a reasonable accommodation or an effective modification so that someone can do something like a wheelchair or a walker or a cane, right? Or technology that allows someone to read a particular website, right? That's what I want you to think about when you think about service animals under the law, all right? I want you to think about those inanimate objects because that's generally what the law looks at service animals as, just like a wheelchair, just like a cane, all right? Here's another misconception. Service animals can be any breed, weight, or size. Oftentimes we'll get calls to our office, well, there was a service animal in our local ShopRite, and it was a tiny little dog, so there's no way it could have been a service animal. As you know, as long as it's trained, by this point, you know as long as it's trained to perform a particular task, that dog is still a service animal, just like a larger dog would be, all right? These are working animals and not pets. Right? Oftentimes you'll see folks will have vests that say, do not touch me, I'm a working animal, I'm a pet. And we'll go into whether that's required or not in a bit. But the reality is that if you see a service animal, or you see any dog for that matter as a dog owner, you don't want to approach that dog and pet that animal. That doesn't mean that you can't go up and ask the individual, hey, is there a time that I can pet this dog? Is it appropriate for me to pet this dog, just like you would someone who has a normal dog that doesn't perform a particular service? All right, and again, dogs can and must be under control at all times. Generally speaking, when we say under control, we're referring to that service animal being tethered. The two exceptions are that, one, if that dog needs to perform a particular task to be off leash, I mentioned one before, Ptsd dog, going into a particular room and scanning that out, that doesn't really work on having someone's leash. The other only distinction that would be allowed is if someone's disability doesn't allow them to carry a tether or a leash, whether because they very well may be missing a limb, very well because they may have a balance issue. But the whole point is that some way, some sort of fashion, whether it's by voice control, okay, whether it's by signing, that animal needs to be under control at all times. Okay, so again, we get questions in our office. Well, this person has a service animal, it says so on their vest, but they're barking completely out of control. Well, that very well may be a service animal. They may be trained to perform a particular task, but you very well may be able to exclude that animal in that circumstance because it's not under control during that time period, right? That being said, we all make mistakes, right? So one bark, you're not going to necessarily kick someone out. But if that dog is out of control in any way, sort, or fashion, even if it's technically a service animal, under the law, that means for that period of time it's not, and you very well may be able to exclude that service animal during that time period. Another obligation is that that animal must be housebroken. Again, I said it, we all make mistakes, but generally speaking, that animal should be 100% housebroken and you shouldn't have any accidents. And if you do, or there's repeated accidents, we can talk about how those circumstances play out and how you can make sure that you're excluding that animal during that time period while still offering access to that individual to your program, activity, or service. And finally, that dog may not pose a direct threat to the health and safety of others. One of the biggest things we get is that, well, it's a pit bull and people are afraid of pit bulls, or it's just a dog or a miniature horse and folks are afraid of dogs and miniature horses. Or even better yet, we get questions about allergies. Someone has an allergy. How do we deal with those circumstances? That last one I'm going to get to in a bit in a frequently asked question. But when we talk about direct threat, we're referring to an animal being out of control, growling, barking, biting, snapping at someone. That's a direct threat. Just because someone very well may happen to be afraid and very well, believe it or not, may have a disability that makes them afraid of a particular animal, that's something you need to bounce. And the answer should never be that that automatically meets a direct threat and we're going to exclude that animal in those circumstances. Again, later on I'd be happy to talk about how to deal with particular circumstances that may come up, but generally speaking, that's the case. So one of the things I want to talk about while we're still on service animals, right? We're not talking about the airplanes, we're not talking about housing at this point, or emotional support animals. We're simply referring to where can service animals go relative to places that are open to the general public. I want to go through a couple FAQs, and I'm going to answer my own questions here, but I think these are the things that we often get asked most at our office. What does under control mean? Right? And I think this is a review of what we talked about. It means that that animal must be harnessed, tethered, or leashed unless these interfere with the animal's work or a person's disability prevents the use of these items. A dog should not bark repeatedly in a quiet place. Barking once or because it has been provoked does not necessarily mean a dog is out of control. I think these are really good guidelines that further go into what I had talked about relative to what does under control really mean in a particular environment. What if someone has an allergy to dogs? Isn't that a disability too? It's probably the number one question that we get asked. Allergies are not a permissible reason to deny entry to a person with a service animal, but places may have to accommodate both parties. Allergies may or may not rise to the level of a disability because, right, if we go back to the definition, it has to substantially limit a major life function or a bodily function, right? Excuse me, major life activity or a bodily function. When we talk about substantial limitation, we're not saying severely limit someone, we're saying substantially limit, which means someone that's limited compared to someone in the general public. So someone's allergy may not rise to that level, even if they have an allergy, but it very well may. If possible, both parties could be separated without excluding either, right? So for example, if we have a particular course at a school and we have someone who has an allergy in that class, and we have another person who has a service animal, a dog or a horse, how do we deal with those circumstances? Well, we very well may need to do something where we separate those individuals. And that very well may not be enough, okay? So what else could we do? Well, we very well may want to provide something in which we could provide one class to one person, and very well may have someone who's an underclassman, an example, take that course later on, all right? That may be some sort of way in which we need to accommodate both people, because someone's allergy may be a person with a disability, and obviously someone who has a service animal is a person with a disability, right? And keep in mind, and this is really important in the bottom, you very well may not be able to accommodate everyone in every situation. And I think that's a misconception under the ADA, in that we always have to solve problems under the ADA. The Americans with Disabilities Act requires you to enter into the interactive process when you're accommodating someone. What does that mean? That means that you're having a conversation about what you can do to accommodate those individuals and what you can provide to them as effective alternatives if you can't give them exactly what they're asking for. That's what the law requires you do. So if you're doing that with both of those parties and you're doing it in a confidential format, right? From a legal perspective, and I look at cases on a daily basis on the ADA, Section 504 of the Rehab Act, all the state cases. I look at this on a daily basis. I've almost never seen anyone ultimately overturn a judge an accommodation decision in which an entity entered in good faith into the interactive process, right? So keep in mind, there are limits to providing reasonable accommodations. The important thing is that you've done everything that you can do from a school entity in that scenario to try to make sure that folks are accommodated, and you've gone as far as you possibly can to try to accommodate both of those parties. All right? Oftentimes, when we get questions, we often think that it would be very helpful for us to go in and be able to do a training, right? But oftentimes, as you can see, that's not an easy thing to do with a 2-hour training, right? So what we try to do is, and again, I'm going to send this around with the slides, with the other materials that I'm going to be sending around to everyone who signs in, which I hope that you folks do, is that we're going to send out a copy of the literature that we have on hand. All right, so our office actually has a brochure relative to the duties and obligations and the limitations of service animals in places that are open to the public. Oftentimes when you're dealing with a person who very well may think they have a service animal or not have a service animal, or there may be some sort of dispute around what questions you're allowed to ask to determine whether something's a service animal, which I'm about to go into. It's very important to have something with our letterhead on the top of it. We found that to be very helpful to sort of alleviate folks' stress, alleviate a very conflicting sort of situation. So we would ask, and I've actually, the last time I did this training was for the 83rd State Trooper class, which just graduated yesterday. And I had folks that came up to me, there was about 200 of them, that said, I'm going to carry around those brochures in our trooper vehicle. All right? I don't necessarily think you always need to go that far, but again, I think it's a very helpful thing to have on hand. We've found that to be the case. Do service animals have to wear a vest or patch or special harness identifying them as service animals? No, okay? Laws do not require service animals to wear a vest, ID tag, harness, or any other identifying items, okay? So any service animal that has those doesn't necessarily give them any special standing under the law relative to the Americans with Disabilities Act. That being said, some individuals choose to use such items even though they are not required and they don't give any special legal standing, okay? I had mentioned the fact that certain folks very well may be comfortable, although again, I highly suggest you don't do it, walking up to a particular dog and petting that animal right off the bat. You know, you should ask no matter what, right? Because you have no idea what that animal's propensity is. But more importantly, now that you know, you very well may want to ask because that animal could be performing a particular task and you may have no clue that it is a service animal because it's not wearing a vest or a patch or a harness. All right? Really, really important thing to understand that. Does the ADA require that service animals be certified as service animals? No. Covered entities may not require documentation such as proof that the animal has been certified, trained, or licensed as a service animal as a condition for entry into a public place. Entities that sell service animal certification or registration documents, they're absolutely out there. You can go online, and I'll talk about it on this next slide. There's a whole sort of industry out there relative to suggesting that animals are certified or licensed, or we're going to get them the vest that says that they're a service animal. But again, there's no legal requirement. It doesn't give any legal standing. The whole rationale and the purpose behind that is that we didn't want folks to be able to have to be pulling out that documentation information every single time. Not to mention, I mentioned certain animals and certain people's disabilities may have a shorter life. So it would be an administrative difficulty for any state or local government or any body or board to accurately capture whether a particular animal is trained to do something during a particular service. Right? When we're referring to the ADA, we're referring to equal opportunity and access to persons with disabilities. These things would all cause sorts of barriers relative to someone being able to get an animal that can help them. Not to mention the financial aspect of it. Right? These documents do not convey any rights under any applicable laws that we're referring to here today. Enforcement agencies, more importantly, do not recognize them as proof that the dog is a service animal. Right? So it's not just the courts, it's not just me saying it, it's the Department of Justice, it's the Office of Civil Rights of the Department of Education, Office of Civil Rights of Housing and Community Development, Health and Human Services on the federal level. None of them recognize any of this when we're referring to individuals coming in to places that are open to the public. As I mentioned here, there are tons. I know you can't probably see this well on this form here, but if you type in "buy service animal vest" in Google, you'll get all sorts of stuff that will come up here, right? U.S. Service Cat Registry, the #1 U.S. registry database. As we know, service animals can't be cats, right? Emotional support animal vest, right? No legal standing there. We see all the different vests and emotional support letters. Need an ESA letter, an emotional support animal letter. Service dog vest and patches, right? There's all these industries out there. And again, just because someone wants to utilize one of those to maybe make things clear to folks that aren't educated on this, doesn't mean that it carries any legal standing. So this begs the question, right? I can't, if it doesn't have a vest, we don't have documentation, I can't ask this, I can't do that. Evan, how am I supposed to figure out whether an animal is a service animal? Well, again, we know service animals can just be horses, miniature horses, and dogs, right? So anything outside of that we know is not a service animal under the ADA. But what can you do to try to figure that out relative to folks that are coming into your places that are open to the public? If you're not sure that the dog or miniature horse is a service animal, you may ask the handler only 2 questions, and sometimes only 1 if the answer, depending on the answer of the first question. You can ask if it is a service animal required because of a disability. If that person says yes, then you can ask, what work does that animal perform? That's it. And if that person gives you an answer as to what work that animal performs, it reminds me to take my medication. It alleviates my stress by licking me on the face when I'm having a panic attack. It it goes and scans a room to report back on whether that's going to be a stressful situation for me, right? Those are the only two things you're allowed to ask for. Now that begs another question, right, Evan? Well, man, that's not going to be enough. What if the person's lying to me about that animal being a service animal, right? We see another article here that says, tightening the leash on fake service dogs. Can states stop people from trying to pass off their pets as service animals? And I'll tell you right now that there are a couple bills in the Massachusetts legislature that are trying to do just that. Our office has our own opinions on it. Generally speaking, we think that they would be preempted by the Americans with Disabilities Act, and they wouldn't be allowed simply because of what we've mentioned right here. The ADA says you're only allowed to ask these two questions, right? So what if they're lying? Well, simple answer. The law requires you to take the person at their word. Now remember, we are not talking about having service animals from someone who's on the job and wants to bring a service animal in. That's not what this training's about. That goes under the general scope of reasonable accommodations. There's certain factors that you can consider relative to someone having a service animal on the job. Same thing on the plane. What we're referring to here is folks that are using your services from the general public, right? And that should give you a sort of indication that these are really transitory. These are quick interactions for the most part, right? These are things in which folks are trying to utilize programs, activities, and services that are open to the general public, right? So we're not going to require that folks provide all this information relative to the status of their animal as a service animal. But remember, and this is a really important point, and I think this wins a lot of people over that are scratching their head on, oh my gosh, this is just ripe for non-compliance. There's going to be all these animals running all over amok and doing whatever they do, and these people that are lying and they're getting something special that I'm not getting, right? I'm saying this not because I believe it, I'm saying this because we hear this all the time from folks. But remember, service animals must be under control at all times, housebroken, right, and may not pose a direct threat to the health and safety of others, all right? So if those animals don't meet any of those standards, you can remove that animal. You can ask that person to remove that animal, all right? If the handler does not correct the behavior, you can ask that person to remove that animal. However, you must still provide access to and services to that particular person without that animal being there. I'm going to stop right now because I know that we're going to take a quick break right here. I went a couple minutes over. I have one more point to add on this. But again, during the 5-minute break, you can come up and ask me some questions. I do want to touch on a couple quick things that I got some questions about, and I think it's worthy of a conversation at this point. What about pools? What about city pools? Do we have to allow service animals in our city pools? The Department of Justice has answered this question in their frequently asked question documents, about a year old now, in which service animals can be excluded from the actual pool, but you still need to provide the ability for someone to have a service animal around that pool area. So all the other services, the sitting areas, everything outside of the water, you have to allow that service animal in. I also got a question about prisons. Do we need to allow service animals in prisons? This is a question I dealt with last week. It's an interesting one. You may say, Evan, why are we talking about prisons here? You know, there's certain folks, they've done something wrong, they're in prison. Why is that? That's not open to the public, right? But the reality is, like I said, anything that touches a state and local government in which we have a program, an activity, or a service, in this case, the act of being prison is a service of the government, believe it or not. And because of that, we very well may have obligations to allow service animals. Generally speaking, in my opinion, I think you have a better argument from a local prison standpoint to suggest that, well, the individual who is imprisoned in that cell, generally speaking, isn't allowed to go outside. They have all their services in there because it's a temporary holding cell. That may be a fundamental alteration, may be a fundamental alteration. Remember, the key is you enter into the interactive process, has to be case specific, to allow that person to bring that animal outside, right? We talked about the ability and the requirement that service animals under the handler's control, there's no duty for other entities to take care of that animal. However, if we're talking about not a temporary holding cell, but maybe a state penitentiary in which they have a therapy dog program in, so we've shown that there are dogs, there are animals in this prison, right? They've passed the security clearance. What would be the issue with us allowing someone to have a service animal in that environment when also they're allowed to go outside twice a day to be able to relieve that animal, and they have enough money to pay to feed that animal? Obviously, depending on the particular circumstances, depending on the security clearance, I could see how that could be reasonable, right? I could see how that wouldn't fundamentally alter that prison's policies around that, right? That's just generally speaking to give you a clue about how you analyze and how we would analyze one of those cases. Another one was restaurants. Do we have to allow service animals in restaurants? We know that state, local health codes suggest that that pets aren't allowed in the restaurant environment. And just like the pool question, the Department of Justice has answered this question and suggests that yes, service animals are allowed in restaurants just like anyone else. And they're also allowed to follow that person up to the salad bar and things of that nature. We talked about, also I got a question about, well, what about an open kitchen environment? Well, I've seen open kitchen environments, and there's always some sort of a barrier, right? So that dog very well may not be allowed, could be, but may not be allowed for one of those employees. But generally speaking, you're going to have those barriers apparent. Okay, and then the last one I want to touch on here is the supermarket. Same thing as the restaurant, right? We have to allow someone to have a service animal into the supermarket. That's a Title III entity. That's a public accommodation. What is that again? A private business that's open to the general public. You very well may, however, be able to exclude a service animal from sitting in the cart, right? That's not something that you would have to allow that person to have. But if it's a tiny animal, it doesn't have the vest, it's following someone around in the supermarket, that you very well should and are allowed to allow that person to have that service animal in that environment. Okay. Another FAQ. And we have a lot of emergent response people and local government officials here, so I think this is good. Must a service animal be allowed to ride in an ambulance with its handler? And the answer is generally yes. However, if an ambulance is crowded and the dog's presence would interfere with the emergency medical staff's ability to treat the patient, staff should make other arrangements to have the dog transported to the hospital. All right? We talked about this. We talked about, and I alluded to the fact of who's responsible for the care and supervision of a service animal. And emphatically, in every circumstance, the Department of Justice will tell you that the handler is responsible for caring for and supervising the service animal, which includes toileting, feeding, grooming, and veterinary care. Covered entities are not obligated to supervise or otherwise care for a service animal, okay? Now that begs the question. What happens if a person who uses a service animal is unable to care for or supervise their animal? Right? I mentioned the local prison scenario, right? In a state penitentiary, no one's getting arrested. They've already been arrested. They've been in that location. When we're talking about a municipality's temporary holding cell, we're talking about an arresting event. We're talking about all sorts of processes in which someone has to go through, fingerprinting, pictures, documentation, things of that nature, that very well may be circumstances in which that service animal may not be able to be with that person during that time period, right? We may have to allow them later in the holding cell, maybe not. Again, if they're not allowed to go outside, there's different arguments there to the fundamental alteration. But we know if someone's been hospitalized or placed under arrest, right, they very well may be put into circumstances in which they're not required, in which that animal is not able to be cared for by that handler in that particular circumstance. I have had this conversation multiple times with folks at the U.S. Department of Justice that there is this gray area, this necessary area in which these things happen, and how do we deal with these circumstances? Well, if a person is not able to care for a service animal, the person can and should make arrangements for a family member or friend to come to provide these services in a hospital situation or to take the dog, all right? If the person is unable to arrange for someone else to take the dog, an entity may place the dog in a boarding facility until the person is released or make other appropriate arrangements. However, the entity must give the person the opportunity to make arrangements for the dog's care before taking such steps. All right? So if you are police and you're in a circumstance in which you're arresting someone, this very well may be difficult, right? This may be difficult on how you're going to deal with this. And what I suggest is, because it's a gray area, is that you have some sort of policy on how you're going to deal with these things. In fact, our office in the hospital environment has worked very closely, and I won't give you the name of the organization, but a large hospital that has a service animal policy that we help them advise them on and worked with them through training and through assistance and advice on that service animal policy. And I explained to them that these things very well may happen. And they said, you know what, I said, you're not really clear where the law suggests how long you need to hold the animal for before you call the people, or how much time you may have to wait until you call animal services. So I said, so why don't you have a policy on it? How do you guys feel about this? And it's funny because the entire leadership of this humongous hospital entity said, you know what, we're actually okay with taking care of this animal for 12 hours, right? And here's the parameters. We're going to have a little bit of food on staff. We're going to have a walk or two during this 12-hour period in which we are trying to reach the individual's family members to try to get someone to pick up this service animal, right? So again, when we're dealing with gray areas, when we're unsure on how we want to deal with it, be proactive about it. Be proactive about the policy. Understand that if you're in a hospital environment, understand if that you're a policing authority, there are these necessary cases in which this will come up for. And again, I watched the case law on these issues. Oftentimes, if you're proactive in these areas and you've thought about what circumstances you may have, and you have a policy on it, even if things aren't necessarily 100% right, you're not going to get an enforcement agency or a court to suggest that, oh my gosh, we're going to nitpick on this, that, and the other thing, right? I'm not saying you want to do it sloppily, but I'm saying that it shows that you've thought about the fact that you have to accommodate individuals. You've thought about service animals and how you're going to deal with those circumstances. Now, if you're running a homeless shelter and and someone says, I need you to walk my dog, or I need you to feed my animal, right? There are no obligations for you to do that. There are absolutely no obligations for you to do that in those circumstances. That is completely distinct from someone not having the ability because of an emergency in a hospital, or because of losing their freedom temporarily because of an arrest circumstance, that they can't take care of that animal. All right, so those are the distinctions there. Vaccination, health codes, and licensure. State or local health codes cannot be used as a reason to deny access to a service animal, all right? Example, in establishments that prepare food, right? We talked about that, again, in the actual preparation side, in the employee side. I'd be happy to talk with you about that. Give our office a call on how to deal with employees relative to service animals in the food environment. Obviously, it's case by case, it's fact specific, but generally speaking, in the environment of restaurants that are open to the public, the health codes are not going to not allow someone to have a service animal in that restaurant, right? Because remember, we're talking about reasonable modifications of policies, practices, and procedures. You can have a no pets policy, but you can't have a no service animal policy. All right? And how do you figure out if it's a service animal? You ask those two questions. And what if someone's lying to you? Well, it's the same circumstance as if you have a service animal that is behaving very well as if you have someone who very well may be lying about that being a service animal, but it's housebroken, it's under control, and it isn't posing a direct threat. All right? I wish I could give you more guidance on that, but that is what the law allows you to ask. All right? So you've got to follow within the law. Can't ask about the person's disability. Can't ask for that animal to perform a particular task. This is what the law allows you to ask for. And I can tell you right now, and this is a slight tangent, but I think we have enough time to do it. I said that one of the areas that my colleague Rita D'Annunzio and I train often is in the higher education environment. Right? We often train, and so because of that, I often look at case law and guidance from the Department of Justice and the Office of Civil Rights for the Department of Education on service animal cases and disability-related cases. And there's one relative to a school that had a service animal policy, trained their employees of that service animal policy, right? Knew that there was a proper intake process, voluntary intake process for that service animal, right? And what happened one night is that one of the security guards for that higher education institution saw a service animal and started asking more questions than they were allowed to ask for, and ended up denying that person access to that building for with that service animal. And guess what? That's exactly the types of cases that the Department of Justice, the Office of Civil Rights, Department of Education wants, because it shows that this has got to be a top-down understanding relative to service animals. Even if you have a policy, right? Even if you think that everyone's trained on it, it's really important to give us a call and have us do training for you folks. Or have folks take a look at the information on our website, right? Or have someone else come in and talk about these issues. Because that was a weakest link circumstance, and in that case, that higher education institution was required to provide and pay for training for every single one of the members of their faculty and staff. They were required to be reviewed by the Department of Justice relative to their service animal policies and their treatment of persons with disabilities. And oftentimes when the Department of Justice, the Office of Civil Rights, federal entities that enforce these laws get involved, they also build in their settlement agreements that they're allowed to show up and pop up every once in a while within a certain amount of time to review these types of matters and to maybe test something out to see if that training and everything was remediated properly. So I'd often ask that you folks think about that. I know it's a slight tangent relative to the entities that you work for, to ensure that it's not just that you are okay with it, that you bring this information back to all the folks of your entity. That's a really important thing. That's mostly why my job exists, because it's not just training the top brass, it's not just training the people on the front lines, it's making sure that your entire entity understands these obligations. All right, so vaccinations. Service animals are not exempt from local animal control or public health requests that dogs be vaccinated. However, I'd be very careful on this issue, okay? And I've actually, again, talked for 1 or 2 years with the Department of Justice on this specific issue on, well, can an entity exclude someone if there's no vaccination or proper vaccination? Are they allowed to ask about that proper vaccination? And my answer that I've been given is that you want to be very careful in excluding anyone for that vaccination. You want to make sure in your agreements with folks for service animals and your voluntary agreements with service animals, and your required agreements for emotional support animals, that you have language in there that is the understanding that all of our employees or all of the members from the public or our students have the proper vaccinations for their animals, right? The whole point is that we're not necessarily discriminating against this person, but we really don't want to ask the questions and go into that. It's a local health issue. Okay, it's dealt with specific to how that entity's local laws require vaccinations. Be happy to talk about that. Give me a call if you're coming up with a policy or you're running into that issue. Give me a call. Licensure. Service animals are subject to local dog licensing and registration requirements, right? So again, we very well can't require a fee for someone having a service animal, but a state very well may be subject to local dog licensing and registration requirements, right? Massachusetts state law, I believe there is a provision in there where certain municipalities can elect to not have folks pay for the dog licensure for service animals, okay? So again, that's specific to the locality in which you're in, but also you want to look at your state law relative to whether it's mandating a particular municipality to do something or whether it's discretionary in which the municipality can make a decision on whether they want to charge or not charge. Is a voluntary registry program for people with service or assistance animals legal under the ADA? There's one word in there that should give this away. Voluntary, that's it, I heard it, yes. Entities, yes, such as local governments may offer voluntary registries. Many communities maintain a voluntary registry that serves a purpose, right? There's a purpose as to why we want to know the answer of whether someone has a service animal, right? To ensure, for example, that emergency staff know where to look for the animals during an emergency. That's a good reason to have a voluntary registry. Registries for purposes like this that are voluntary are permitted under the ADA. An entity may not, however, require that a dog be registered as a service animal as a condition of being permitted. As we know, being registered as a service animal doesn't even really exist. So that's something to keep in mind. Again, voluntary nature of these things is really important. A little bit different in the higher education setting relative to emotional support animals. That's under the Fair Housing Act, you very well may be able to have a little more leniency into the registration of emotional support animals than you do service animals. We're going to go into that in a little bit. We're going to go into it right now. Immersion emotional support animals. What are we talking about here? We're referring to animals that are not pets, right? They're kind of the in-betweens, I would say, right? They provide emotional support that alleviates identified symptoms or effects of a person's disability. They are not required and are not individually trained or certified, right? That's the distinction. They don't recognize and respond. The simple presence provides emotional support to a particular individual. And if you think all the way back, well, Evan, there's a gray area between that and psychiatric service animals. Go back to that slide we talked about earlier, and you'll see the distinctions between how animals can be service animals that help someone with a psychiatric disability versus someone, the simple presence of an animal being there helping someone alleviate particular symptoms of a psychiatric nature and anxiety, okay? Commonly dogs, but here's an important point, they can be other animals, right? Emotional support animals, unlike service animals, which are just dogs and miniature horses, emotional support animals can run the gamut. Okay? They're not specifically defined in the ADA or Section 504 of the Rehab Act. Okay? And what are those? What is Section 504 again? Section 504 provides a lot of similar provisions that are in the ADA relative to equal access and duties to accommodate persons with disabilities as the ADA has, but it's tied to the receipt of federal funding. And actually another funny little side note here is that, well, why do we need the ADA if we have Section 504 of the Rehab Act? Well, just like lawyers were making the arguments, as I mentioned before, that the ADA, the person with a disability under the ADA, well, if they don't meet that strict definition, well, then we don't have to accommodate them. A lot of lawyers have been able to bring up a lot of litigation and suggest that, no, this entity in and of itself does not receive federal funding, right? Maybe portions of a state's town the public school systems, things of that nature receive federal funding, but we as the Public Works Department don't receive federal funding, right? So there's all sorts of issues relative to what does it mean to really receive federal funding. So one of the reasons as to why the ADA is an important thing, because if you are a state and local government, if you are a location that is open to the general public as a private entity, you have to meet these requirements. It's a little more clear. So again, I thought I'd go into that a little bit. All right, they are, however, right, so when we talk about the ADA, right, and this is where it could get a little tricky here, but I want to mention this, and I'm going to give you a great slide to help explain emotional support animals. When we talk about, and I mentioned it before, under the ADA, Title II, state and local governments, public accommodations, have to provide reasonable accommodations, right? They have to provide equal access, and they have to modify policies, practices, and procedures under the ADA, right? So the whole point here being that we may have a circumstance in which an animal doesn't meet the definition of a service animal under the ADA, but we may have to consider allowing that animal anyways as a modification of their policies, practices, and procedures if it's required because of a disability, right? And in those circumstances, when you ask those first two questions about it not being a service animal, right, you're going to know that it's not a service animal right away. And then you're very well are in a good circumstance to ask a little more questions about it if someone says, well, it's not a service animal. No, it doesn't perform a particular task, but it's an emotional support animal. I need it because of my disability. Well, you can then have a conversation about that, right? Keeping in mind, and I'm going to go into it in a bit, that if it doesn't fundamentally alter your program, activity, or service, it isn't a burden on your circumstance, you very well may still have to allow that person to have that animal. My whole point being that if it's an emotional support animal and it doesn't do anything, really the only argument someone can have is say that because of my anxiety, for example, I can't get out of bed in the morning and do anything unless I have this animal by my side, right? That's the argument that person's going to have to make. That's up for you and your entities to evaluate. I'm just letting you know, in certain circumstances, you may have to allow emotional support animals even if they're not service animals. And the most important thing in there is that you have that conversation, right? That you enter into that interactive process. You try to figure out why that person's suggesting that they need it, okay? Emotional support animals are specifically mentioned in the Fair Housing Act and the Air Carrier Access Act. So I mentioned, and I love higher education institutions, so I'm going to go back to that because I just think they're such a unique location in what the different types of entities that they have on campus. For example, they could be owned by state and local government, so they could have Title II obligations. They could have areas, auditoriums, gymnasiums, things that are open to the general public. Right, so there could be Title III portions on it. They could have dwellings, right, housing units. So they're under the auspices of the Fair Housing Act, right? So when we talk about Fair Housing Act, we're referring to dwellings and things that are attached thereto, right? And the Air Carrier Access Act, which I'll go into detail in a minute about, we're referring to airplanes. All right, so the Fair Housing Act. Housing providers must modify no pets policies to allow a resident to have an assistance or an emotional support animal needed because of a disability. All right, this includes emotional support animals. Now this, if you're paying attention, this this next line will still be in line with what I'm saying here, in which a housing provider can require documentation of a disability if the need is not obvious, okay? Why can we do that? Why can we do that in the housing environment? Well, we can do that when we can't do it with service animals. We can do it with emotional support animals because we're dealing with the Fair Housing Act. And their scope is, and their rules and their laws under the Fair Housing Act are a little more wide than the service animals are. Now, if someone wants a service animal in the housing context, you always start with the service animal evaluation, okay? And if it's a service animal, you can't ask for the documentation. If it turns out it's an emotional support animal, you can ask for the documentation, as long as it's not obvious, right? As long as the need and the disability are not obvious, you can ask for that information, All right, you're allowed to go into detail about that. Again, I would call our office if you're in a circumstance in which you have someone in your housing unit, they want an emotional support animal, give our office a call. We can help guide you through and give you technical assistance as to where the law stands on that issue in your particular circumstance. And again, I like to talk about rationales as to why the law is the way it is. Why are we allowed to ask for this? Well, again, they're not as robust of providing assistance to individuals as service animals. They don't perform a particular type of task. Also, I mentioned entities that are open to the general public. We usually have these quick interactions for the most part in most circumstances. Not the case in housing, right? These people are in these units for a lot longer time. They're their house. So we very well may be able to ask for a little more documentation for emotional support animals under the Fair Housing Law if the need and the disability are not obvious. This is kind of a way to bring it all together in, again, one of the more unique environments. So I added this slide of the overlapping laws on campus, right? You can see that higher education institutions could be public places under the ADA in Section 504. These are the recreation facilities, the lecture halls, libraries, dining halls, bookstores, right? And you can see if you go down to the middle, you have to allow service animals into all those areas, right? And you also go down to the left, well, you may have to provide reasonable modifications, right, on a case-by-case basis of a particular policy, right? Or academic adjustments, individualized assessments on what we need to provide to students in the classroom setting. And that's where you see the overlap with emotional support animals, right? So even though service animals, they're necessarily allowed, unless there's a fundamental alteration, you very well may have to require, at least consider, someone bringing an emotional support animal onto campus, right? Fair Housing Act, if you go to the right, Housing, Fair Housing Act, ADA, Section 504, we're referring to the dorms, apartments, common areas in housing, laundry rooms, rec room, kitchen or bathroom on a campus. Well, these very well, service animals, assistance animal, emotional support animals, may be allowed for as reasonable accommodations and are absolutely allowed for relative to service animals. So you can see there's a lot of overlap here. And the important thing is when you're peeling these issues off and you're struggling with them, give our office a call. We can help you out with that. But know that nothing's a clear answer, right? And there shouldn't be decisions that are made that are snap judgment decisions that say, we don't allow emotional support animals, period. And why do I say that? From a legal aspect, I say that because what happens when you give a snap judgment? You don't have any evidence to show that you did what's required under the law, entering into the interactive process, having that conversation that I mentioned before, doing a case-by-case analysis, an individualized assessment, as the courts call it, with a requirement of good faith. So if you don't have those conversations and you say, well, we did it for one person before, and that's very similar to what we're doing with here, so I don't need to do that analysis, you'd be wrong. You'd be wrong, right? And that's why I often say, you folks don't have to worry about the slippery slope arguments, right? Because there's a requirement to do an individualized assessment every time you get a request for a reasonable accommodation or a reasonable modification of your policies, practices, and procedures. You got to do it all over again, right? So there's no slippery slope there. These are requirements by the law that you need to enter into. So when you don't have the evidence to show that I called facilities to see if it could work in this dormitory versus this one, or we now have new leadership, I want to check with them to see where we stand, right? All these sorts of factors you want to be able to have, because if you do ultimately deny someone having an emotional support animal because it fundamentally alters your program activity or service. If you're a public entity, for example, you have to make those decisions by a higher level official, and they need to be in writing, and that becomes a public document. And the whole reason for that is so that entities don't rush to judgment and simply claim, well, I know under the law if it's a fundamental alteration, then I don't need to allow it, and it's a fundamental alteration. Well, when you have that, the judge has no evidence, or the enforcement agency has no evidence to be able to show that you did all the legwork, even if you did it. So that's why you want to write that stuff down That's a very important thing that I often talk about to all of our state and local governments. So, Air Carrier Access Act, we added this very recently to our training. We often used to say, well, this is not in planes and just good luck. But we actually added, I think I mentioned I did, Rita and I did a training for state troopers recently in the academy, and we were asked to talk about the Air Carrier Access Act, because I don't know if you've ever been to Logan Airport or any of the airports. State troopers actually deal with a lot of those areas relative to enforcement. So they asked us to do this. I think it's an important thing to talk about relative to these questions of service animals in the general public. We then talked about housing. We're now talking about the other big area of where we talk about emotional support and service animals. So under the Air Carrier Access Act, airlines must permit passengers to travel with an animal needed because of a disability. They must be allowed to travel in the cabin at no additional cost, and this includes, within its scope, emotional support animals, okay? And that is oftentimes why you'll see a lot of these animals on the planes, right? And why is there a big issue? And I'll go into the legalities of it, but not too much to bore you, that these regulations, these laws are getting reviewed right now because they are ripe for abuse. All right, we've talked about people coming in the general public. Yeah, sure, there's animals that people are lying about, service animals, but as you can see, airlines, they love to charge for this, right? So if you have a pet, they're going to charge you $100 each way, right? So a lot of people, this is very ripe for abuse because there's a benefit to non-compliance here, and that is not having to pay to have your pet on the plane. It's a little unique here, and in the way that the law breaks down emotional support and service animals. Unlike with the ADA, under the Air Carrier Access Act, psychiatric service animals are considered emotional support animals. That's the way that the law is written, right? So service animals, an airline must accept identification cards, right? Other written documentation, harnesses, tags, or credible verbal assurances that that animal is a service animal. And that's how they kind of get around some of those issues that we would deal with the certification and all that stuff. They can just, if someone credibly says that this is a service animal, I don't know how that really plays out, but that's what they suggest that can meet that service animal definition. Now, emotional support or psychiatric service animals, there are different requirements that you need to show for that in the airline setting. An airline can require current documentation on letterhead of a licensed mental health professional, right? And it states one of the following. The passengers has a mental or emotional disability recognized in that the diagnostic manual. The passenger needs the animal as an accommodation for air travel or at the destination. Individual providing assessment is a licensed mental health professional, and the passenger is under his or her professional care, and the date and type of mental health professional license in state or other jurisdiction of issue. I'm sorry, I mentioned that it needs to have all of those, right? So if it's not a service animal, right, under our general understanding of what we've talked about, but it's an emotional support animal or a psychiatric service animal, those are the requirements. Air Carrier Access Act, type of animals. Airlines are never required to accommodate certain unusual service animals, right? Snakes, other reptiles, ferrets, rodents, and spiders, okay? Again, I would often say give our office a call before you enter in this process, right? There are also other factors in which these airlines are allowed to, that I can't touch on such a short training, are allowed to consider relative to international travel, in which the destination goes to and what they're allowed to have relative to that. With respect to all other animals, including unusual or exotic animals, a carrier must determine whether any factors preclude their traveling in the cabin as service animals, right? Whether they're too large or heavy to be accommodated, whether an animal would pose a direct threat, whether it would cause a significant disruption, whether it would be prohibited from entering the country that is the flight's destination. If no such factors preclude the animal from traveling in the cabin, the carrier must permit it to do so. Also, another question that I often get on this is, well, if someone, what do we go back to that allergy circumstance? What if someone has an allergy? How do we deal with that? There are certain bumping provisions relative to that person being separated from that person if there's space on the plane. If not, that person may be asked to get off the plane, deplane, and go back on the next plane if they have an allergy or an issue. So what I often suggest is that folks call ahead, because this is very fact specific relative to the destination, the type of animal that you're bringing, and specific to the policies that that particular entity has. I know, and I just read, again, I look at this stuff very often for my job, and I know that Delta has now ramped up their program relative to allowing electronic submittal of this documentation for folks to have it on file for a longer period of time. So again, you want to call ahead and figure out what are the parameters relative to where you're going, the airline specifically, the type of animal that you have. These are all things that you definitely want to look into before you're bringing your emotional support or service animal into a plane. Okay, so for folks of you that need more information, like I said, we are going to be providing our training, which is accessible to screen reader technologies. I'm going to be emailing that to the folks that are running this. I'm going to be emailing a document relative to service animals and emotional support animals, the brochure that I mentioned before. And I'm also going to be sending out some evaluations. So if you folks could fill those out truthfully, it's very helpful. Like I said, I really appreciate it if you guys sign in and get credit for being here. That really helps us allow to go out and do trainings for folks like you. If you have other opportunities for training, we're often looking for opportunities to provide training to places that are open to the public, to state and local governments. We don't just do trainings that are general like this one, right? So oftentimes we will tailor them to specific circumstances. I mentioned the state police, higher education institutions will often touch on, and not just also specific to service animals and emotional support animals. Anything relative to civil rights and disability, we provide training on, and in my opinion, I think we do a very good job of it. So I really appreciate your time today. Thank you very much.